Give me a second. Yes.
Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Belize, hearing of CCJ's appeal BZCV number 1 of 2019 between Bay Trust Corporate Services Limited and Karen Acosta Longsworth. Hearing this appeal is their honors, Mr. Justice Saunders, President, Mr. Justice Anderson, Madam Justice Rajnat Lee, Mr. Justice Burgess, and Mr. Justice Jamador. Please state your appearances for the court.
May it please Your Honor, Rodwell Williams, along with Ms. Lissette Stain and Mr. Adler Waite for the appellant in this matter, my learned friend, Mr. Eamon Courtney, Senior Counsel, along with Ms. Naima Barrow, for the respondent.
Yes, Mr. Williams.
Obliged. Your Honors, if I may begin at the beginning, I must confess that having looked at the case management orders and sought to follow them diligently, we were overnight ambushed with a speaking note that has been filed. Although we did in fact prepared speaking notes, unfortunately we did not file them, nor are they in a position or in a form to be filed. In the circumstances, we are still ready to proceed, but we will seek Your Honor's leave, perhaps, to be able to file in due course all speaking notes, merely to ensure that the record would reflect a balanced situation in the circumstances, and we would be in a position to do so not later than Monday of next week, if Your Honors are minded or disposed to allow us to put all speaking notes on written record before the court.
Well, I don't know whether it is necessary, because we have your written submissions, and I would imagine that the note is not going to be a further response, a second response to
Indeed
anything
not.
that is being said,
Indeed not.
but rather is a distillation of your written submissions. So in that sense, I mean, if you wish to do it, then that's fine, but it won't be necessary.
It won't be necessary. I'm grateful. In the circumstances, then I'll proceed at a high level. I would like to suggest, based on our submission, or written submission, which the court do have the benefit of.
Yes. Of course, if there's anything in Mr. Courtney's speaking note which is not reflected in his written submissions, then you can feel free to deal with it on your feet now.
Indeed. And I intend to.
Yes.
Your Honor, this case at this stage, really, comes out of a situation where, and I think I would begin with my friend's speaking notes, where he indicates that it is entirely a question of attribution, the principle by which the conduct, intention, and so on of a person in a company may be attributed to the company. And we do not disagree, essentially, with that. However, it is my intention to demonstrate to this court that, in fact, this entire matter from its commencement, that the question of attribution was, in fact, never pleaded at first instance, where the matter was heard before the trial judge. No submission was ever made squarely on the issue.
No submission was ever made what?
Squarely on that issue. On arrival at the Court of Appeal and below, it was always the contention of the claimant respondent that, and by their pleadings, as I will seek to show, that the matter was all about the application of the idiomatic principles in relation to a decision that a company may make by consensus. And that is where the case was entirely pleaded, argued, below, and at the Court of Appeal. And that at the close of the oral hearing, and there are written submissions and so on that I may direct the court's attention to. At the close of the hearing, that's how the entire case rested, pleaded, argued, submission, and the notion of attribution was never a part of it. Some 2 years later, after the oral hearing, some 2 years later, the parties were summoned before the court by, well, to submit, to put in written submissions on the question of attribution. And the parties did so.
But at that point, did you resist this novel point?
Well, yes. In the written submissions we did. We did not resist the invitation to make the submissions. We complied with the request of the court. But we resisted the notion that insofar as the conduct of the Mr. Glen Wilson was concerned, the chairman of the company, that his conduct or statements could not be attributed to this appellant company. And our written submissions.
Wait. You're saying two things there. There's one thing which is a point of principle, that the issue of attribution never arose on the pleadings, that it was a novel point which ought not now to be taken. And then there's another issue, namely that, okay, assuming that this is a point that can be taken, the conduct of Mr. Wilson could not be attributed to the company. I'm not clear whether it is one or the other or both of these points that you're saying you took.
Both of those points were taken in the further submission some 2 years after the actual oral arguments.
Before the trial court or the Court of Appeal?
Before the Court of Appeal. See, for clarity, the trial occurred based on the pleadings as they were, and there was a determination by the trial judge. The matter went on appeal. The grounds of appeal, the arguments and submission of the appeal, nowhere did the question of attribution arose. The submissions were closed, the oral arguments were presented, and 2 years after that point, the question of attribution was brought, and the parties were invited then to make submissions. That's the sequence.
Am I getting you right? Because I'm not clear at all, Mr. Williams,
I'm sorry.
that you objected to put it in further submissions? That is what I'm trying to locate, because I have the further written submissions you filed. I believe I do. So
We did not object to put in the submission. We simply complied with the written request that was made via the registrar of the Court of Appeal, and we did not have audience with the court. This was simply on paper.
I understand.
This was done. But the two issues, in fact, were taken by us insofar as the fact that the matter never arose absolutely. And secondly, that assuming the attribution principle applied, that when one applied to the facts and circumstances of this case, our position is that the conduct of Mr. Wilson cannot be attributed to the company, and I will quickly seek to show that. Permit me, Your Honors, to, first of all, direct the court's attention to paragraph 5 of the statement of claim, which is at page 727 of the Court of Appeal records. Page 727, paragraph 5. But I say curiously, neither the word attribution nor any of the cases related thereto was ever relied upon by the respondent.
I'm getting a little bit confused, as some of my colleagues seem to be. I find your recounting of the chronology interesting.
Yeah.
But at this point, where we are now, are we going to be fighting the battle again as to whether attribution is something that we can look at, Or are you now saying that the actions of Mr. Wilson ought not to be attributed to your client?
I do not intend to fight the battle, so to speak, in relation to the fact that attribution was never squarely at play in the entire proceeding until the Court of Appeal invited the submission.
Mr. Wilson, much of what you have said for the past going on 15 minutes seem to be revolving around that issue. So if it is not relevant at this point, wouldn't it be more productive for us to look to see whether the actions of Mr. Wilson can in fact be attributed to the company?
Well, certainly, and our approach, if I'm permitted, is to take the court directly to what was, to the decision of the Court of Appeal of Belize in relation to how they arrive at their decision on the basis of the attribution principle.
Sure.
Permitted. Yes. And I would like to direct the court's attention to 75 of the bundle, the record of the Court of Appeal, with reference to the decision of Justice Appeal Morrison. And I believe at paragraph 6 and 7, let's see, the undo. About 6 and 7, yeah. At 6, Learned Justice Moore said, given the learned trial judge very clear finding on, if I may say so, very clear evidence that the appellant had been constructively dismissed, I found this to be a startling conclusion. So much so that I was initially inclined to think that the appeal should be allowed on the basis of idiomatic principle, which is the principal basis put forward by Mr. Barrow, Senior Counsel, in support of the appeal. But I have subsequently come to doubt whether that is a tenable approach, given the fact that the appellant's pleaded case was that she was dismissed by the respondent's email dated 16 July 2011, redesignated her status, and not by some kind of implied resolution of the board arising out of the meeting between the appellant and Mr. Wilson on the 18th of July 2011. To go the idiomatic route now, therefore, would necessarily involve a reordering of the facts of the case to give the appellant remedy on a basis not pleaded by her. At paragraph 7, this therefore led me to consider whether some or other basis might not be found to support the appellant's case, given my clear view, based on the now current findings of fact on constructive dismissal, that the justice of the case is plainly in her favor. In further written submission dated 13 February 2018, submitted at the invitation of the court, Messrs. Barr and Williams for the respondent contended that the learned trial judge's conclusion was unassailable, given the well-known company law principles of attribution. In this regard, Messrs. Barr and Williams, on the decision of the House of Lords in Meridian Global Funds Management, in that case, Lord Hoffman referred at page 506 to it being a necessary part of corporate personality that there should be rules by which acts are attributed to the company, describing these rules as rules of attribution. As rules of attribution. Lord Hoffman went on to say, and it is described, could you go further? And the law is described by Lord Hoffman is set out. And my comment here is that having taken the position, Mr. Justice Morrison, having taken the position, Justice of Appeal Morrison, that at paragraph 7, that therefore, having come to the conclusion, agreeing with the trial judge that the basis on which the case was pleaded and argued was not maintainable, that he felt that there was some other basis on which the matter ought to be decided, and that's when he had sought to apply the attribution principle. My first comment is that, with respect, it is our view that the Justice of Appeal misunderstood the ruling of the learned trial judge, primarily by reordering the facts as found by the learned trial judge. We submit that the trial judge did not find the respondent was constructively dismissed. We consider that to be a fundamental error there. The judge found that the action of Mr. Wilson were not that of the appellant, and therefore there was no constructive dismissal. That is our view as to what the trial judge really found. Where the judgment is, and our position is that when the judgment is understood in its proper context, it becomes plain that the Court of Appeal erred in interpreting what the judge actually found. Now, permit me, Your Honors, to direct the Court's attention to page 262 of the record. I think it's paragraph 19 insofar as the trial judge's finding in relation to that. And you have that? Page 262. It's that paragraph. Okay, I can see it clearly. You got to take it down a little bit that way. Yeah, so it's go up a little bit. I would like to, before directing the court's attention to that, to say that somewhat curiously, the trial judge had the principles of attribution in mind, it seems to us, when she stated in the segment that I'm about to bring to Your Honor's attention, that redesignation from a majority shareholder cannot be attributed to any action by the appellant company against whom this claim has been brought. If I may begin at page 262 of the bundle, the record says, and this is from the trial judge's decision, reasoning, the contract is what governed the relationship between Mrs. Longsworth and the defendant company. Mr. Wilson had no authority on his own to change the terms of her contract. He personally had no authority to dismiss her constructively or otherwise. The contract clearly states that the employer, BTCSL, and the employee, Mrs. Longsworth, a resolution had to have been passed by BTCSL before any such change could take place. A company is governed by its constitution, that is its memorandum and articles of association. The company carries out its action through its resolution in general meeting and extraordinary meeting. For example, Mr. Wilson had gone, if Mr. Wilson had gone on, no, I haven't finished it. For example, the company carries out its actions through its resolution in general meeting and extraordinary meeting.
Yes, we see all of that, but tell me something. If Mr. Wilson had done that, would you have regarded that as constructive or actual dismissal?
Well, if Mr. Wilson had gone ahead and effected his desire, his will, by way of the resolution or by way of consensus or agreement with Ms. Longsworth, diplomatic-wise, on basis of that principle, or by simply carrying out or effect his proposal. Our case has been that these were a series of proposals that were being put over a limited period of time.
No, my question is related to the judge's use of the phrase constructive dismissal following the hypothetical situation that she adverts to immediately before. And I'm saying if that hypothesis had been actualized, whether it would have been a proper conclusion to say that there was a constructive dismissal or whether there was, in fact, a dismissal, a wrongful dismissal.
Well, certainly if the proposal was effected by way of the exercise of the provisions of the articles in terms of a resolution and so on, it is our view that it would have been constructive dismissal.
I see. Okay.
Mr. Williams, earlier in that same judgment, the judge at page 252 looked at the first issue according to her and asked the question, did the redesignation amount to a breach? Is it possible that this is what Justice of Appeal Morrison was speaking about when he seems to suggest, or at least I understand it to be, that there was a prior finding by the judge and then a subsequent finding which, according to him, I don't know if he used the word startled or words to that effect. He was surprised then to see, because I'm looking at page 258, and the judge appeared there to be saying that what had been done had in this plan of action entitled The Way Forward was designed to strip the claimant, as she then was before the trial court, of a management of the company. And the judge concludes at page 258, in my view, it went to the root of a contract. So isn't that what Justice Morrison is referring to, that initial finding by the judge? And then he says, surprisingly though, she comes to a different decision that there was some prematurity or there was an abandonment by Ms. Longsworth. Isn't this what he's dealing with?
Well, this is where in our view, the misconstruing of what the trial judge was getting at. What I understand it to be saying is that, look, this is a proposal that is made by the chairman of the company and so on. And this follows on a series of proposals. This particular proposal was not accepted. The others were. If this proposal is implemented by the requirements regarding the articles, then that would be a constructive dismissal, because if it's implemented, it goes to the root of Mrs. Longsworth's contract. If it's accepted, or if it's implemented, it goes to the root of her contract. The trial judge went on to find that given it was not implemented, that in fact it remained a proposal, and she referred to the notion of a proposal at least 5 times in her determination of the matter, that then it could not really be constructive dismissal. However, because it was not implemented, however, the Court of Appeal took the view that that proposal in and of itself, even though it was not implemented, and their view was that the trial judge determined, when in fact on the record, certainly it appears to us that the trial judge did not come to the conclusion, she came to a different conclusion, that it was not in fact constructive dismissal.
At page 263, I think it's paragraph 14, the last part, I think you may have, as it stands, that piece of the judgment, where the trial judge says, repeats what you just said, it's merely a proposal, and then goes on to say, you have yes.
Yes.
It cannot be attributed to any action by the company against whom this claim has been brought. So what do you make of that? What do you say about that?
As it stands, this is merely a proposal for redesignation from the majority shareholder and cannot be attributed to any action by the defendant company against whom the claim has been brought. I understand that to mean that having found that this was a proposal, having determined that only if it is effected or implemented by the process which is required by the company, resolution or some informality by way of consensus or agreement, the diomatic approach, then it's effected. And if it's effected, then it's a constructive dismissal.
So in terms of what we are interrogating here, attribution, is this of any significance?
Well, in terms of attribution, yes, and I intend to, as I continue to explore the determination of the Court of Appeals to specifically, if I may, Your Honor,
Sure.
Address it. So effectively what we are saying at this juncture is that Court of Appeal misconstrued the finding of the trial judge, and so they erred in that fundamental misconstruction. Thank you. And that particular portion that we just read on page 263, I think, makes that quite clear. In fact, I would go on to point out that, curiously, even though there was no square argument or any argument at all on attribution, the actual trial judge at page 263 of the bundle, or 262, I'm sorry, of the bundle, said this: curiously, the trial judge had the principles in our view of attribution in mind when she clearly stated that redesignation from a majority shareholder cannot be, and she used the word, attributed to any action by the appellant company against whom this claim has been brought. So she used the, if I may loosely say, the magic words. However, there was no detailed analysis of the cases, but certainly that was her conclusion. Permit me, Your Honors, to perhaps direct the majority decision, and this was of the Court of Appeal. It was a majority decision, but Justice of Appeal Morrison came to certain conclusions, perhaps on a different principle or basis than the majority, but they all come to a common conclusion in terms of how the appeal must go. And Justice of Appeal Awich, with whom the President of the Court of Appeal agreed, without any reasoning, the President agreed, but adopted the reasoning of Justice of Appeal Awich. Permit me, Your Honor, to perhaps look firstly at Justice of Appeal Morrison's approach. And that essentially may be found on page 77 of the record. Sorry, page 76 of the record. And paragraphs 9, 10, 11, and 12. It's preceded by, in paragraph 7 of Ms. Justice of Appeal Morrison's reasoning, after he rejected the idiomatic approach to determine the case and declared that, he said at paragraph 7, this therefore led me to consider whether some or other basis might not be found to support the appellant's case. Given my clear view, based on the now concurrent findings of fact on constructive dismissal, that the justice of the case is plainly in her favor, meaning the appellant's favor, and so on. We say, beginning there, that that was a misconstruing of what the trial judge actually found. And that's the genesis of why, in our respectful opinion, our respectful view, he went wrong. Then he continued now on at paragraph 9, 76 of the bundle. he considered one of the leading cases in terms of attribution, Bilter, and said this: in his brief concurrence in that case, now Nuremberger observed at paragraph 9 that whether or not it is appropriate to attribute an action by or a state of mind of a company director or agent to the company or the agent's principal in relation to a particular claim against the company or the principal must depend on the nature and factual context of the claim in question. And Lords Tolson and Hodge observed that where a third party makes a claim against the company, the rules of agency will normally suffice to attribute to the company not only the act of the director or employee, but also his or her state of mind where relevant. And he therefore took the approach that, in his view, the principle of agency was, in his view, the best approach to fashion a remedy for the respondent, because his view was that the justice of the case required it. Our view in that regard is that the case, as I said earlier, was actually devoid of any attribution, submission or pleadings and so on.
So, would it be your view that in paragraph 8 of his judgment, Justice Morrison seems to take the issue of attribution off the table? Is that it?
Well, it's not quite clear whether he took it off the table in the sense that he says at paragraph 8. In this case, the respondent submit, it is the primary rule of attribution based on Article 80 which applies, and therefore in the absence of a residual. So, in effect, that was all submission, written submission there. And he simply recited that that was our position, and then went on to utilize the notion of agency as the basis on which he was prepared to make the determination. He did not at all, in our respectful view, make a determination squarely on the attribution principles. I would hazard a guess to say that he perhaps appreciated that in terms of the analysis of the attribution principle, that to some degree it covers the notion of agency. And so to some degree, given, and I will perhaps direct the court attention to that aspect of our submission in which we actually stipulated really the elements of the attribution principle.
Let me see if I understand you. You're saying that, look, attribution is a legal principle.
A legal principle.
If attribution is off the table because of the rules of law that constitute what is attributable,
right,
then it is not appropriate or proper, or one is incapable of using agency to get around the inability to use attribution. That's your submission.
That's the submission. And we emphasize that in our written submission by seeking to demonstrate that insofar as the principle of agency is concerned, when looked at in the context of this particular case, clearly, Mrs. Longsworth was not a third party in the strictest sense, insofar as agency as between a third party and the company appellant is concerned. we submitted and we say that in terms of yes, and we draw the court's attention to we draw the court's attention to Law of Contract Common Law series. We learned it authors a stipulation. It's yes, thank you. They put it succinctly: where a principal, in conferring authority upon his agent to act on his behalf, imposes conditions or limitations on its exercise, no act done by the agent in excess of the conditional or limited authority is treated as the act of the principal in relation to such persons who have or ought to have notice of such excess of authority, or have had notice of an irregularity, placing them upon inquiry as to whether the agent's authority was being exceeded. In their submission, the respondent says that the company appellant was the principal, that Mr. Wilson was the agent, and Ms. Karen Longsworth was the third party. We say on the facts of this case, Karen Longsworth has throughout conducted herself in such a manner and was aware at all times what were the limitations that, for instance, the articles of the company impose on the directors insofar as the exercise of power or authority to dismiss the managing director.
Yeah, but wasn't she also in a position, in a very good position, to be aware that Mr. Wilson had it within his power to do what was necessary to effect a dismissal?
Indeed, and if we look at the other side, and the evidence as it turned demonstrated that, one, Mrs. Longsworth at all times, for instance, she said that she decided early in 2011 to change her contract, for instance, managing director, to say, look, I needed to ensure that Mr. Wilson don't have a supermajority, so she took 30% of the authorized capital or shares in the company. He, therefore, could not have a supermajority, which would require 75%. She altered her contract to change it from a 1-month notice to terminate to a fixed date contract of 5 years. And she expressly said, and it's brought out in the cross-examination of Ms. Longsworth, that she was doing all these things to secure her position. She was an insider. She was a person who actively expressed that she was conversant with the rules of the law, the limitations.
I'm not sure I've answered the President's question. I thought the question was whether Mr. Wilson was in a position to ensure that the proposal he put forward was in fact carried by the Board of Directors.
Mr. Wilson, and in the position that Mr. Wilson was in as the chairman of the company, as a director, and if there was a formal or informal meeting of the company, he would have been in a position, let's say in a formal meeting, to, and Mrs. Longsworth let's say, is objecting to seek to effect that proposal, yes, he was in a position to do that. He did not do that.
And she knew that he was in that position, clearly.
And she knew that he was in a position. In spite of all the various things that she did to, as she said, secure her position vis-a-vis Mr. Wilson. So my point is that Mrs. Longsworth cannot be treated as a third party in the context of this relationship.
So all that Mr. Wilson had to do then was to call a meeting of the directors, himself and Mrs. Is it Longsworth? Yes.
Yes.
So that's what he, basically, that's all that was to be done, a formal meeting. And
A formal meeting.
Okay.
Or if Ms. Longsworth, as she said, didn't agree with the proposal, the question is, she could have herself, let's say, given her status in the company, she had the option of actually saying, well, if she wanted to get out of this situation, let's say, Mr. Wilson didn't press to force the implementation of the proposal. He didn't do that. On the evidence, what happened is that, and they couldn't agree, but he did not force any of those powers which he obviously had. Mrs. Longsworth, incidentally, if she wanted to, let's say, force a situation also, she could requisition meetings. So, and she knew all these things, and all these things were brought out in her cross-examination, that she was well capable and knowledgeable with regard to her own position as a director and a 30% shareholder in this company. But she did not attempt to trigger those things. Neither did Mr. Wilson. When they had the confrontation on the 18th of July, when they had that confrontation, she simply indicated, oh, we can't agree, I will go and get advice and you will hear from me. We say that before Mr. Wilson could even effect this proposal, what happened is that Mrs. Longsworth, in fact, jumped before she was pushed. And that's what brought us to this state of affairs. And the trial judge, in fact, determined that, look, she acted prematurely.
Yes, well, if you know that you're about to be pushed and you have no way of not being pushed, as seems to be the case here with his casting vote, then, you know, she might have decided, well, I might as well go because there's really no recourse that I have. The fact of the matter is, I mean, a formal meeting could have been called, clearly. But the fact of the matter is that he had it within his power to pass this resolution in favor of the proposal. And there's nothing legally that she could do about it.
Well, that is correct, but on the basis of the principles here, really, especially with regard to the fact that she could not ultimately, if Mr. Wilson pressed to implement these proposals, could not, then she would not be in a legal position to prevent it.
And you don't think the series of emails passing between them was indication of his pressing?
Well, that's in terms of really his view as to, look, I think I can perhaps implement this. And he gave some kind of peremptory kind of dictate. Yes, I am the chairman, I'm the majority shareholder, and so forth and so on.
That sounds like pressing to me. That sounds like pressing to me.
No, I think if one look at the evidence so far as how this encounter broke up on the 18th of July, no indication, no suggestion that if they can't come to agreement that Mr. Wilson would have sought to effect the proposal. In fact, when Mrs. Longsworth exit the encounter, the indication, and this comes out of the testimony of Mr. Wilson also at first instance, was that he understood that she was going to consult and that they would have some further discussion on this matter. So he was entirely flat-footed and caught off guard when the following day the company was served with the claim. And this is why I maintain and strongly submit that, and I describe it as she jumped before she was pushed. And this is why I find, and I support the view, I'm sorry. This is why I support the view that the trial judge had it right.
Sorry,
That
Mr. Williams, I'm sorry to break your train of thought, but you'd question Justice Appeal Morrison's use of the agency principle, and you were looking at the question of the authority of the company, what authority had been given to Mr. Wilson. But you never concluded your discussion of that. You cited from a book on the law of contract, but you never concluded, at least in my mind, you never concluded what this court should think of Mr. Justice Morrison's use of the agency principle to attribute, or at least to impose liability on the company. And that's a question of law, and I think that that's a question which you may want to return to at this point in time, because you still have to deal with attribution, I think.
yes.
Mm-hmm. Yes, Mr. Williams, you're so running out of time. It might be better for you to go straight to the issues of law, as my brother, Justice Burgess, indicates. One on Morrison's conclusion on agency, and then Justice Orwich's conclusion, which was with President agreed, President Sosa, on attribution, because I don't know.
I think my time is...
Quite a bit to do in a short period of time.
Very well. I'll try and see what I can do in the remaining time. The legal principle with regard to agency is founded on the basis that where the third party is concerned, where the third party is aware there is some knowledge in the third party that there is a limitation, a qualification, insofar as the principal and the agent is concerned, insofar as the scope or extent of the agent's authority. And the third party is aware of that and is fixed with notice whether the third party knows it or ought to know. Then the third party, therefore, with that knowledge, it begs the question, what authority the respondent, he's a true insider, they're aware of that limitation on the agent's authority, so they can't seek to clothe themselves or wrap themselves in the benefit of the notion that Mr. Wilson was really the agent in this context, given the facts of this case.
I rather thought that your argument was slightly different, or I was anticipating a slightly different argument. I thought you were going to argue that the company itself was limited to how it could dismiss, and therefore could not, if it didn't have authority beyond that, couldn't confer such authority on its...
On the agent.
On the agent.
Yes.
I thought that that's the line of reasoning that you were pursuing.
I accept that line.
But
Your
it
Honor.
wasn't given to you to accept. I thought, I'm just trying to say that I thought that's how you...
I accept that line, and perhaps I put it in a somewhat obtuse way, and forgive me. What I'm directing at is that the company had a qualification insofar as the authority how to dismiss the managing director. And that knowledge was well known to the managing director, the third party. And therefore,
To the
the
world.
agent,
To the world.
Therefore, this agent, Mr. Wilson, was also aware of that qualification on him. If we say he's the agent of the company, he then cannot exceed that authority insofar as his agency may be concerned. And that was well known to both of them. This is why I maintain that absent a meeting or a consensus or a resolution going the route that the articles prescribe for removing the managing director, then we'll have to conclude as a trial judge that Ms. Longsworth jumped before she was pushed. But there was no indication up to that point, certainly, when she jumped, that she would have been pushed, even though, and I concede.
But Mr. Williamson, going back to jumping and pushing again, when what we thought that you were arguing is that Mr. Justice of Appeal Morrison applied the agency principle wrongly. I thought that that's, you haven't, because you haven't even got to, as my sister has pointed out, you haven't got to, attribution is it.
Attribution is it. I would rest that aspect by saying it is our view, our submission, that Mr. Justice Morrison applied the agency principle wrongly in the context of the fact that the limitation that is imposed on the principle insofar as the process is concerned, Mr. Wilson therefore cannot take from that by himself exercise a power which he doesn't have, which is in the company.
And you say the respondent was well aware of that.
And the respondent was well aware of that.
So therefore, she could not have made an assumption that Wilson was clothed with any agency because of her knowledge. Isn't that what you're trying to say?
That I'm grateful
Yeah.
to Your Honor.
Okay, thank you.
Can I turn to attribution? I think I still have.
Yes, you don't have a lot of time to do so.
I'm obliged. On the matter of the attribution, our submission is that the actions or knowledge of a person can only be attributed to a company by means of the, 1, the general principles of agency, 2, the primary rules of attribution found primarily in the company's constitution and implied by company law, and or 3, special rules of attribution. And this comes out of the Meridian decision. Our submission is that it is only when a rule of law, either expressly or by implication, excludes attribution on the basis of the general principles of agency or vicarious liability, for instance. That is, where the application of the general rules of agency and the primary rules of attribution would defeat the intended application of a legal rule to a company that the special rule of attribution should then be applied to determine whose acts and principles for a specific purpose should be attributed to the company. So what we're saying is that in respect of the primary rules of attribution, the Articles of Association of the appellant company expressly set out the means by which the respondent may be dismissed or removed by the company. And that's through the board of directors. The facts of this case we submit does not lend support to the respondent case, as there was no meeting, but I think we have dealt with that earlier. There was no meeting in which a resolution was expressly or impliedly passed, either by a majority vote or unanimous consent. This then means that there can never, does not mean that there can never be a case of constructive dismissal, as one reflects on the reasons Mr. Justice Morrison suggested, that on that basis which I just mentioned, then there can never be a case of constructive dismissal. We disagree with that view, and we quickly say that there can be constructive dismissal if, for instance, on this same facts, let's say Mrs. Longsworth agreed with Mr. Wilson's proposal, then whether formally or informally, diomatic would apply. And if she had accepted, then informally, there would have been a consensus and diomatic applied, and there would be constructive dismissal would follow. Similarly, we could give another example where, for instance, our employer, the company, or an official of the company in a higher echelon of the company as against employee lower down, if that particular person conduct themselves in a particular way, which entitles that lower down employee to find it unreasonable to continue, that can be an instance of constructive dismissal where the higher employee's conduct or action is attributed to the company and so forth and so on. But we say in this case, this respondent cannot rely on the principles neither of agency nor the primary rules of attribution, as indicated earlier. We further go on to say that the court must always be cautious in invoking special rules of attribution. That is, the third category, when the primary rules and the company rules and so on, and the secondary rules of attribution are not available. One can go to look at the third category. But, and this is a caution given by, in Meridian, the starting point is to identify a rule which requires construction. So whenever one seeks to go to the third category, there ought to be a rule, there should be a rule which requires some construction. And it seems to us that Justice of Appeal, which alluded to some rule outside, and that is section 42A, which of the Labor Act, which is produced. You could go to that for me, please. 42A reads as follows. An employee is entitled to terminate the contract of employment without notice or with less notice than that to which the employee is entitled by any statutory provision or contractual term where the employer's conduct has made it unreasonable to expect the worker to continue the employment relationship.
What statute is this?
The Labor Act of Belize, Section 42A.
Okay.
Which I've just read, and I
Yes,
think
it's on screen.
it's on screen, yes, thank you. The specific question here then, to be answered is whether, for the purposes of Section 42A, Mr. Wilson's conduct should be regarded as the conduct of the appellant company, having regard to the policy behind that provision and the factual circumstances of this case. Our submission is that the purpose of Section 42A appears to be to balance the rights and obligations as between an employer and employee, that it codifies the circumstances under which an employee is entitled to terminate his or her contract of employment due to certain unreasonable acts of the employer, and in so doing, restrict those acts to those of the employer to the exclusion of all others. This is our view in terms of the policy and the object and intent behind Section 42A. So then, the employer would not be held liable for every unreasonable conduct against an employee that occurs in the course of employment. Looking at the specific facts of this case, we submit that the respondent does not fall in a category of employees who have little or no influence and power over their employment and or employer. She's not, in the truest sense, one would say, submissive or subordinate employee, in the truest sense. In fact, as we said earlier, and I reiterate that she was quite aware of her level of power and influence in the appellant company. We submit and we say that by her own admission, she took not less than 30% of the appellant shares so that Mr. Wilson would not have a supermajority, and obliges him, irrespective of his intention, that he's obliged insofar as her role in the company and her contract.
Yeah, you gave us a particular,
I gave that already. So I go to 42A, I'm obliged. We say and submit that 42A does not expressly or by implication exclude attribution on the normal basis, that is agency and corporate rules. Employees may generally rely on the principles of agency and the primary rules of attribution to attribute a person's unreasonable conduct to that of the employer. Thus, application of those rules would not defeat the intention of 42.
But, Mr. Williams, you may perhaps want to comment on the words in Section 42A, where the employer's conduct, don't we have to interpret employers?
There is a
Employer, and isn't there room for saying that this employer includes the company and anyone acting on behalf of the company, not necessarily with authority, as you, so as to say, one is relying on agency, but the employer's conduct? Isn't it possible to find on the special rules of attribution an application of the Meridian principle? That's just a question. Because you haven't commented on that. And that's a critical part of the, in my respectful view, that's a critical part of 42A.
Of 42A. 42A, there's a definition of employer, I believe, and perhaps I could
First, please.
direct the court's attention to that definition. The Labor Act says that employer means any person, firm, corporation, company, or body of persons who or which has entered into an agreement or contract to employ any worker. So employer could mean any person
Or company,
or a company, specifically,
which is a persona fictitive.
which is a
and which has to
artificial
act-
persona.
Yes, and which has to act through agents, or, well, not agents, but certainly natural persons.
It has to act through natural person, it has to act in compliance
So
with
its
its...
conduct, the conduct of the company will be the conduct of natural persons.
Yes, yes. Yes, in that sense, yes, certainly. So we do not disagree with that notion. Simply what we're saying is that in the context of the facts of this case, if we arrive at attribution in this third sense, the special rule, if we arrive there, we are saying that the approach the courts have taken over time, consistently, is that then you have to look to whether there is some rule of law, as in this particular case, Section 42A, which, in a sense, mandate that one could fashion a special rule to ensure that the rules of attribution are not intended to be ousted. We say that 42 does not oust the general rules in terms of attribution, that 42A is not intended to oust those rules. So we do accept that in relation to 42, the rules, the general rules and secondary rules do apply.
So you're saying your construction of 42A means that the provision there was not meant to oust.
Yes.
These are the rules of attribution.
That apply, yeah.
Now, do you have any cases or authorities that would persuade us to interpret 42A in the way that you are arguing for?
The very Meridian case and their lordships sought to demonstrate when you go to, or when the need arises to, let's say, fashion a written submission. That case may be found at tab 8, sorry. It's not, I don't know if they...
We have it. So, in other words, it's the Meridian case that you're relying on, is it?
Yes,
Okay.
I'm obliged.
Mr. Williams, how much longer would you be?
Not much longer. Your Honor, I crave the indulgence just so that I could make the point.
You don't have a lot of time.
I'm obliged, and I...
Yes, go ahead.
So then, on page 8 of that decision, the judgment of Lord Hoffman, and here he's referring to the use of the words that Justice of Appeal, which used in so far as the directing mind and will and what it means, because it seems to us that Justice of Appeal would simply use those phrases, but gave no analysis or indication as to how he arrived there, and use them as a kind of shortcut to find that Mr. Wilson was the will and mind of the company. Ipso facto, his conduct is to be attributed to the appellant company.
I think you may have misunderstood. I'm not sure if you're responding to the question I asked, but if you are, you may have misunderstood the question. I was simply asking you if there are any cases on Section 42A of the Labor Act which give the kind of interpretation of the provision that you are
That
arguing
I'm
for.
advancing.
That was all I was asking.
No, Your Honor, I must concede and confess that we found no law which attempt to analyze that particular provision, Section 42A. So it is only our own submission that we are able to stand upon.
Okay.
And we say that it does not oust the general and secondary rules of attribution. So one could go right back there.
Okay.
But so we are saying that this is not a case on the facts that one needs to, in fact, seek to fashion a special rule. And it seems to us, and our submission is that certain justices of appeal, with whom the president agreed, simply adopted mind and will without bearing in mind the caution that Lord Goddard expressed in Meridian and the clear indication that, and I quote from Meridian, one possibility is that the court may come to the conclusion that the rule was not intended to apply to companies at all. For example, a law which created an offense by which the only penalty was community service. Another possibility is that the court might interpret the law as meaning that it could apply to a company only on the basis of its primary rules of attribution if the act giving rise to liability was specifically authorized by a resolution of the board or a unanimous agreement of the shareholders. This is expressing what I said earlier in my submission. But that there will be many cases in which neither of these solutions is satisfactory, in which the court considers that the law was intended to apply to companies and that although it excludes ordinary vicarious liability, insistence on the primary rule of attribution would in practice defeat the intention. We say in our view, Section 42 in practice does not defeat that intention. And therefore the regular rules apply. So there is no need in this particular matter at bar to seek to fashion a special rule of attribution, and that seemed to be exactly what Mr. Justice Awich did in relation to his coming to the conclusion that Mr. Wilson is the mind and will and so on of the company, and therefore it attributes to the conduct. His conduct is attributed to the company. That is essentially the substance of our submission, and we therefore conclude by urging this court to allow our appeal and to reverse the decision of the Court of Appeal and to replace it with the decision of the learned trial judge in relation to the counterclaim by the appellant company and for costs here and below. I'm thankful to your honors for allowing me the additional time to make the point.
Yes, thank you. We'll take a 15-minute break and come back at 11:45. Yes, Mr. Courtney.
May it please the court. Your Honors, my learned friend in opening his appeal raised two issues. One, a complaint with respect to my speaking note. I think the court has dealt with that, so I need not make any comment on that. The second is what happened in the Court of Appeal and the implicit criticism, I believe, of the Court of Appeal of dealing with the question of requesting submissions on attribution. The court is well aware that throughout the Caribbean, including Belize, there is the equivalent of Section 19 of the Court of Appeal Act. We have put it up on the screen if the court can see, and it says 19.1, on the hearing of an appeal under this part, the court shall have power to confirm, vary, amend, or set aside the order or make any such order as the Supreme Court or the judge thereof from whose order the appeal is brought might have made or make any order which ought to have been made, and to make such further or other orders as the case may require, etc. 2, the powers of the court under this section may be exercised notwithstanding that no notice of appeal or respondent's notice has been given in respect of any particular part of the decision of the Supreme Court or the judge thereof from whose order the appeal is brought, or by any particular party to the proceedings in that court, or that any ground for allowing the appeal or affirming or varying the decision of that court is not specified in such notice, and the court may make any order on such terms as the court thinks just to ensure the determination on the merits of the real question and controversy between the parties. That is a complete answer to the right of the Court of Appeal to have invited additional submissions.
That statute is the Court of Appeal Act?
Of Belize.
Yes.
Section 19. That is a provision that is invoked from time to time. The second point I make on that is the record should reflect accurately that there is absolutely no objection from pages 106 to 112 of the record raised by the appellant to this request from the Court of Appeal. They did not object. They made full submissions on the question of attribution. It is absolutely too late to seek to raise before this court any complaint in that regard. Your Honors, if I may now turn to the appeal proper, I am compelled to underscore that this is a case of constructive dismissal. It is not a case of Mr. Wilson or the appellant deciding to dismiss Mrs. Longsworth.
Sorry.
And I wish to raise 2 points. Firstly, there is no provision in the Articles of Association of Beatrice that deals with the question of constructive dismissal, as the court would assume. My learned friend made references to the Articles of Association without identifying to this court or relying on any specific article. And I will respectfully submit to this court that none of the articles deal with the issue at hand. In their statement of claim, in their defense, they mention Article 80. Article 80 is on the screen, and it deals with removal of a managing director. It says every managing director shall be liable to be dismissed or removed by the board of directors, and another person may be appointed in his place. Well, simply the facts, that didn't happen. It did not happen. So putting that in your defense carries it nowhere. The board may, however, enter into any agreement with any person who is or is about to become a managing director with regard to the length and terms of his employment, but so that the remedy of any such person or for any breach of such agreement shall be in damages only, and shall have no right or claim to continue in office contrary to the will of the directors or of the company in general meeting. Clearly, what that is implying is the common law rule that it is unlikely, in the absence of statute, where they will force an employer to take an employee where an employer does not wish the employee to be employed and the remedy is in damages. Your Honors, if we can take a look at, and the rest of that doesn't apply, of course, if we can take a look very quickly at Articles 83, 84, sorry, not 83, 84. And in fact, if I just can correct myself, I think my learned friends relied on 84 in their defense, not 80. Whilst Ms. Barrow looks for that, Your Honors, the point I wish to make about 79 and 80 is that 79 provides for the powers of the directors to appoint a managing director, and 80 provides for the managing director to be removed. All of this is done by the board. Article 84, the business of the company shall be managed by the directors, who may pay all expenses incurred in forming and registering the company, and may exercise all such powers of the company as are not by the Act or by these articles required to be exercised by the company in general meeting, subject nevertheless to any provision of these articles and of the Act, and the exercise of such powers shall be subject to also to the control of any general meeting of the company. But no resolution of the company in general meeting shall invalidate any prior act of the directors which would have been valid had that resolution not been passed. Your Honors, I pause because the effect of this is one, again, traditional position, management of a company's business is placed in the hands of the directors. But there is an interesting notion in this specific article that where a decision is taken by management, quote, no resolution of the company in general meeting shall invalidate any prior act of the directors which would have been valid had that resolution not been passed. The facts of this case suggest clearly that that wouldn't arise. But even if Mr. Wilson wanted to then pass a resolution and saying, I am reversing myself on the decision that I took to demote Mrs. Longsworth, the question would be, did he have the power to demote Miss Longsworth as he chose to do, not whether she has a right to bring a claim for constructive dismissal, but where you have management of a company in the hands of two directors and one who has a casting vote says, I have taken a decision, my decision is that you're demoted. And under this rule, it will raise a question whether or not it is at all possible for that decision to be reviewed by the general meeting and reversed. But I just say that in passing. Your Honors, I don't want to take much time with the Articles of Association. My submission is this. The appellant cannot identify any of the articles that apply to the facts of this case. None. This case is about Section 42A of the Labor Act. Now, Your Honors, it is important in my respectful submission to appreciate where we are today. We say, as we say in our speaking note, that the starting position is, as appears in paragraph 3.9 of the written case of the appellant. And I want to take the time to read it. It is on page 1143 of the record. And indeed, my learned friend, in presenting the appeal, restated this position. At 1143, paragraph 3.9, the appellants say, it is to be noted that there was no cross-appeal by the company, nor any demur in its submission that the actions of Mr. Wilson, if attributable to the company, was sufficient to ground a claim of constructive dismissal. It was then accepted that the constructive dismissal would stand if the actions of Mr. Wilson were that of the company. I make a preliminary, relatively unimportant point, but when you read the first sentence, it seems implicit that the appellant recognized that Madam Justice Arana had made a determination, because they say they did not cross-appeal the constructive dismissal point. Your Honors, the concession made in paragraph 3.9 of the submissions is, with respect, dispositive of this appeal. It is dispositive of this appeal in favor of Mrs. Longsworth. Why do I say that? If we go to section 42A of the Labor Act, and I think this was coming out, but it did not fully emerge in the engagement with my learned friend. Section 42A of the Labor Act, which is applicable, and there is no dispute about it, that this is a case of constructive dismissal, says, an employee is entitled to terminate the contract of employment without notice or with less notice than that to which the employer is entitled by any statutory provision or contractual term. And this is the important phrase, where the employer's conduct has made it unreasonable to expect the worker to continue the employment relationship. My learned friend quite rightly presented to this court the definition of employer, which means company. So, where the company's conduct has made it unreasonable to expect the worker to continue the employment relationship, that means by section 42A2 that you are unfairly dismissed. Read along with paragraph 3.9, and I will repeat what 3.9 says. It is then accepted that the constructive dismissal would stand if the actions of Mr. Wilson were that of the company. What section 42A is saying is that one looks at the conduct of the employer. In the case of a company, the company is inanimate, and therefore one has to look at the conduct of its officers and employees, etc. In this particular case, the conduct of Mr. Wilson. The appellants have told this court unequivocally that Mr. Wilson's conduct is unreasonable, has made it unreasonable to expect Mrs. Longsworth to continue the employment relationship.
So, in other words, as I understand you, a company is a legal fiction. It has to act through persons, natural persons. And if Ms. Longworth had to be dismissed, then that dismissal, unless she had acquiesced in it, could only come from Mr. Wilson, from the actions of Mr. Wilson. The company could only have been acting through Mr. Wilson to effect her dismissal, unless she was acquiescent in the dismissal.
That is correct, Your Honor. And, Your Honor, Mr. President, which I will come to and which must be patently obvious, where you have a company that has 2 directors and 2 shareholders, one is a chairman with a casting vote. That same officer is the majority shareholder. And the question arises, the factual question arises, who conceivably could constructively dismiss the other director? There is no one else but Mr. Wilson. The point, however, that I was seeking to establish by Section 42 is that what is before the court is a question of construction of Section 42A and the way in which the statute is crafted. It is to say, when a claim of constructive dismissal is before a court, the court looks to who did what he or she did, when he or she did it, and asks itself the question whether or not, in light of all the circumstances, it is unreasonable for the employee to continue. And I ask this court, on the facts of this case, where you have Mrs. Longsworth, a managing director responsible for Bay Trust, managing all the affairs of Bay Trust, all the employees are below her. All departments of the company, the accounting, the trust, the companies, the banking, etc., are all below her. And Mr. Wilson makes it very clear. With immediate effect, quote unquote, forthwith, quote unquote, you are now responsible only for the trust department. He has, in our respectful submission, demoted her. Is it reasonable for Mrs. Longsworth to continue in employment where she no longer supervises everyone, where she's no longer in charge of the day-to-day operations of the entire company, where she has disciplined and dealt with people in the company and now just demoted to a head of a department and expected to continue? The court, and I raise that rhetorically because on 3.9 of the case, the appellants have answered that question. They have accepted that it's unreasonable. And I'm saying as a matter of statutory construction alone, that's the end of the case. Your Honors, it is set out.
But what if Mr. Wilson said what he said, did what he did, fully expecting that, look, as long as you know that you can't be dismissed unless there is a meeting of the board of directors. No such meeting has been called. And at that meeting, maybe you might be able to persuade me that what I am proposing is not in the best interest of the company and that I should change my mind.
Right. Your Honor, I would say a number of things. The first point is, it was never the intention of Mr. Wilson to dismiss Mrs. Longsworth, as I understand the case. I mean, he's never said that was my ulterior motive. I think we can give him the benefit of the doubt that he had serious concerns and reservations, and he decided that certain things had to change. One was the management structure, if one accepts that. So you move from there, and let's look at the facts. But I go one step before looking at the facts. Assuming that that meeting had taken place, and if Mr. Wilson's intention, as in this particular case, was settled, we know what would have happened. He would have used his casting vote. He has said it repeatedly. I would have dealt with it, and she would have gone. But we're not dealing with a situation where he's saying, I'm going to fire you, and she is given an opportunity to persuade him. We're dealing with a situation where he says, I am demoting you. The facts are, Your Honor, that Mrs. Longsworth, first of all, said to him, I do not accept that you can do this. This is not the right thing. He says, I am the boss, get it done. She says, I'm going to take advice. She went and took advice, and it is important to understand that after taking advice, she came back to him the so-called meeting on the 18th of July. The email was on the 16th, and on the 18th, they met again. He maintained his position.
No, Mr. Cody, wait a minute. The advice was between the 16th and the 18th? Is that the chronology?
As I understand, there were
I had an impression, but may be wrong, I accept, that it was post the 18th she was going to take the advice, and then the decision to leave came. But I may be wrong on that. Can you correct?
we put up on the screen, Your Honor, the original email was the 16th.
That's the right.
Yes, and then she said, I'm going to take advice.
When?
And then see Monday the 18th,
On the 18th, she said, I want to take advice.
it says, upon seeking legal advice, you're
I
already
see.
taken it. I was advised that you're taking over management of the company amounts to a breach of my contract. I'm also not interested in accepting the offer.
When did the meeting happen? That email is at 3:44 p.m., so the meeting happened before that. The meeting on the 18th,
Happened before this.
before, because the email
Yes.
is timeline 3:44 p.m.
Yes.
Okay, I get it, correct.
And
What page in the record is that, please?
that is 876.
Okay, thank you.
And just for completeness, he says, Dear Karen, further to my earlier response. Sorry? In mine it's 876. Further to my earlier response, I made no offer for you to be a general manager of trust. This is a reassignment, redesignation. So he's telling her, even though she says, I have advice that this is wrong. He says, I never offer you anything. Here's a decision that has been taken. You have been reassigned. You have been redesignated. So to answer the president's question, she did go back and say, this is the situation. Then she memorializes it, and he maintains his position that you have been redesignated, you have been reassigned. And I keep repeating ad nauseum the acceptance by the appellant that it would be unreasonable in those circumstances for her to continue. Your Honors, I was going to invite the court to page 1452 of the record, which is the case of Meridian, just to make an important point. At the letter E, 1452 at the letter E. At the letter E, this is taken from Meridian. The fact that the rule of attribution is a matter of interpretation or construction of the relevant substantive rule is shown by contrast between the two decisions of Tesco and Resupply. I simply say to the court that what falls for interpretation in this case is section 42A. That is the section that is implicated. And the question is, if I may put it in the language of paragraph, and I'm going a little quickly, paragraph 191 of the Bilter case. I paraphrase that. That is to be found at page 1519 of the record.
Page?
1519.
Thank you.
Paraphrasing the question posed there. Is Mr. Wilson's conduct or state of mind to be treated as a conduct or state of mind of Bay Trust for the purpose of the constructive dismissal pursuant to section 42A of the Labor Act of Mrs. Longsworth? Paragraph 191 says, the relevance of the context in which a question is asked, is X's conduct or state of mind to be treated as a conduct or state of mind of the company for the purpose in hand? And in fact, my learned friend in his submissions had phrased the question virtually in these identical words. So we're at item on what the question is. And, Your Honors, we have set out in detail the relevant quotations from statements of the chairman of the board, the majority shareholder, the person with the casting vote, and the person who says to Mrs. Longsworth, you are no longer managing director, you are now head of the trust department. I remind the court of what Madam Justice Arana says. That redesignation was stripping her.
Was what?
Stripping her.
Oh.
And that it went to the root of her contract. It is my respectful submission, Your Honors, that it is difficult to conceive of a more paradigm case of attribution. You have two directors, two shareholders. One is the chairman with a casting vote on the board, and the other is the majority shareholder who says, I am the owner. They are, to use Madam Justice Arana's language, a power struggle between them. We see there are significant differences. And he says, I need to decide this. I need to settle this. And the way I'm going to settle it with immediate effect, forthwith, is in the following way. There is no one else with the greatest of respect, looking at the factual matrix, who could have acted in such a way to quote him in the interest of the company. In a way that would make that action of that individual the action of the company. We rely on the statute, we rely on agency to say that Mr. Wilson is the only person who could have done this, and that his actions are indeed...
Mr. Courtney, sorry, you said you're relying on agency. Could you develop that point? I don't think that I understand the way in which you've developed that point. Could you please? Because and I'm not certain, while you're at it, I'm not certain which principle of attribution you are invoking. You make reference to section 42A, but how do we get there? Under the Meridian principles, how do we get there?
Well, I would say, and I'm grateful to clarify, Your Honor, my respectful submission is that the law on this area is, and for obvious reasons, section 42 requires an interpretation of that section, and it requires, in the case of a company, a review, an assessment of the conduct.
Doesn't the Meridian case say that you don't get to that, to the special rules of attribution before you've gone through the primary rules and the general rules?
Well, Your Honor, I was seeking to make a slightly different point. Before we got there, before I got to Meridian, I'm going to go to Meridian.
You haven't reached there yet.
Yes.
I'm sorry to
Right.
preempt you. Yeah.
Now, what I was seeking to establish and to submit to this court is when one looks at the Labor Act, section 42A read together with the definition of employer, which includes a company, and a person brings a claim for constructive dismissal. Put Meridian to one side for the moment. We're looking purely at the act. And the employee says, these are the circumstances that have taken place, and I walk through the door, I have brought my claim. The court makes an assessment of that conduct. And if the court concludes that the persons who did it, that conduct makes it unreasonable for the employee to...
That the persons who did the conduct.
Did the conduct.
Or the
Because-
persons who are acting as the company at that point in time.
Well, yes, I was going to.
It seems to me as though, with respect, one is begging the question, one can't say that because acts are done, that they're done by the company.
No, Your Honor, but-
One still has to go to see who is the company.
I think-
I agree with you that when you look at section 42A, we can read employer to mean company, that we can substitute company there, but we still have to find out who is the company for purposes of section 42.
Right, Your Honor, and I'm saying, I believe we're at item, I am saying that in the assessment of the facts, who did it? A messenger who says something rude or steals money or whatever, says something, cannot, to a superior person, we cannot attribute what that employee says to the company. Clearly, that messenger could not be acting for the company. I'm not getting, so I'm saying,
Except that you mentioned Tesco,
yes,
and Tesco is a case where a departmental head,
very low.
precisely, a very low
Yes.
employee of the company was nevertheless held to be the company.
Yes.
So I don't think that one can rely on the level.
Status.
The
Right.
status, nice word, of the person who is involved. One cannot preempt the inquiry into whether one can attribute the actions
Of that particular person to the company.
Yeah.
Your Honor, I am not at all seeking to avoid that, and I accept that in the analysis of the entire facts and circumstances, one of the most important questions is who is doing whatever he or she has done. And when one determines that, one has to look at that person's status and see whether or not it will be attributed to the company. I accept that. So, when we get to Meridian, and I would prefer to put up the language of Meridian on the screen, which appears in our submissions. I think it's at page 1451. Yes. The primary rules, where are we? Yes. The company's primary rules of attribution will generally be found in its constitution. Typically, the Articles of Association will say things such as, for the purpose of appointing members of the board, a majority of the shareholders shall be a decision of the company, or the decisions of the board in managing the company's business shall be the decision of the company. There are also primary rules of attribution which are not expressly stated in the articles but implied by company law, such as, quote, the unanimous decision of all the shareholders in a solvent company about anything which the company under its memorandum of association has power to do shall be the decision of the company. So it's dealing there with the express and the implied rules at the primary level. These primary rules of attribution are obviously not enough to enable a company to go into the world and do business. Not every act on behalf of the company could be expected to be the subject for a resolution of the board or a unanimous decision of the shareholders. The company therefore builds upon the primary rules of attribution by using general rules of attribution, which are equally available to natural persons, namely the principles of agency. It will appoint servants and agents whose acts, by a combination of the general principles of agency and the company's primary rules of attribution, count as the acts of the company, and we rely on that. And having done so, it will also make itself subject to general rules by which liability for the acts of others can be attributed to natural persons, such as estoppel or ostensible authority in contract and vicarious liability in tort. So, Your Honors, we say, when one looks at the facts of this particular case on the question of agency, Mr. Wilson, by the rules of the company, is the chairman of the board. He is given a casting vote. Mr. Wilson is the majority shareholder holding 70%. There are only 2 directors and there are only 2 shareholders. Mr. Wilson, for all intents and purposes, is primus inter partes. He is, and he says it repeatedly, In addition to that, Your Honors, we would submit that not only the rules of the company, but what he says, the way he has conducted himself, and the intention, he expressly says, I am doing this in my capacity as chairman of the board and majority shareholder. That is the basis on which I have made my decision. When you look at all of that, and you ask yourself, who is the person or persons who could, in the facts of this case, be a person whose actions and deeds should be attributed to the company? In our respectful submission, the agent in that particular case is Mr. Wilson. I go one step further, Your Honors, to continue to make the point that, and
So therefore, you don't need to go to the third category
I
in
was-
your argument. In your argument, you can rest, you say, on the facts of this case in the second category of attribution, not the primary, but on the general principles of agency, construed in the facts of this case. Mr. Wilson was the agent of the company, full stop.
that is the case that we make, Your Honor, and I was simply going to add, for completeness, that if driven to the secondary and the reserve, one would say that this court should fashion a rule, otherwise Section 42 would be defeated.
But the construction of the meridian is the court ought not to reach the third category if it is that either the first or second categories either
Answers
one
the
of those
question.
can be invoked. Is that
Yes.
not right?
Yes, Your Honor.
Yeah.
So I simply said if driven, for completeness.
Yeah, but isn't the appellant saying that here there is a contradiction between the primary rules of attribution and the acts of the managing director as agent?
Your Honor, I heard it, but my response is the following. First of all, and I believe in response to questions from His Honor Justice Burgess, the question of, well, did Mr. Wilson or did the company have the authority to constructively dismiss the person? And if the answer to that is no, then it would follow that the agent could not have had that power, and therefore the argument of agency on that basis would fall. With respect, we would say, first point is that the question of constructive dismissal does not arise from the articles. When you look at the articles deals with express termination. So you can't look to the articles and say, where does the articles provide for a constructive dismissal? If it doesn't, then Mr. Wilson could never have had that power. Mr. Wilson had the power to make, in our respectful submission, on the facts of this case. His conduct is to be attributed, when you look at all the facts and circumstances in the round, that he is the person who had that authority. The question was put, and I accept, had the formality, assuming that a meeting was necessary, had a meeting been held, what would have happened?
Well, we don't know.
I know. I'm trying to figure out why Mr. Wilson didn't call a meeting. I'm trying to figure out why Mr. Wilson didn't testify in court that, listen, now that I see that she has sued, I will reappoint her. And the whole matter would have been finished.
But you see,
The
Mr. Courtney, part of, I think you started your submissions by making an important distinction. There is no evidence to suggest, and you do not seek or suggest, that Mr. Wilson
Right.
is
Okay.
of the 42 is to be construed in the continue in the and all
That is what the case is as I started, that this is not Mr. Wilson or anybody else attempting to dismiss her. This is a decision to demote.
And you buttress that by saying that primary rules of attribution are irrelevant here because there is nothing in the articles that speak to constructive dismissal.
Yes. At the end of the day, and I'm repeating myself now, so I will do it very briefly.
I just want to ask one other thing as you answer that question. Is it then that the intention of the person who acts so unreasonably in the issue of constructive dismissal, that is not relevant to what you...
The intention of the person?
Yes. In other words, you don't have to intend to constructively dismiss someone.
Well, in most cases, I don't think that there is an
Will be
intent.
done,
Right, yeah.
exactly.
In most cases, I don't think the intention is to
Yes.
constructively dismiss. It is that tough decisions are taken in companies for varying reasons, and ex post facto an assessment has to be done as to what is the impact of the conduct and whether it is unreasonable for the employee to...
Or not even tough decisions, treatment. It
Yes.
could be extreme disrespectful treatment, which makes remaining in the employment just unreasonable.
Yes.
Therefore, the law steps in to say that amounts to a dismissal, called constructive dismissal,
Yes.
because it is no longer reasonable for the employee to continue.
Guided, Your Honor.
Yeah, you see, Section 42 is a very important point, very important piece of legislation, because long ago, when people talked about dismissal, nobody thought about constructive dismissal. So those who are labor lawyers, people began to say, no, if you treat me in such a way that I cannot remain, I cannot stay, you cannot hide behind the fact that I didn't dismiss you because you caused me to leave. It is a most interesting aspect of this case that I find fascinating, Mr. Courtney, and I will look at what is available.
Indeed.
There's just one case on which if you can comment, I'd be very grateful. I think would be very helpful to us. I don't know if you've seen the case of Stone and Rolls and Moore Stevens.
I saw it referred to in a book.
Sorry, but if I could quickly expose my problem. Sorry, it's not a problem. Something which I hope your argument can accommodate. This is a case which suggests that unless the company, this is a case where you know that it was a director and shareholder, single director shareholder, who formed a company to effect certain fraudulent banking transactions. The question was whether the actions of the single shareholder managing director, everything, whether his actions, fraudulent activity could be attributed to the company. And the House of Lords, the UK Supreme Court held that yes, it could be, but the only reason was because the company itself was participating was an active participant in the fraudulent design. Now here, I'm not certain whether the company is actually involved in the behavior which leads to constructive dismissal. The cases subsequent to Meridian seem to suggest that Stone and Roll is to be applied in those kinds of situations. I mean, how does your case match up with that principle? If attribution is to be restricted in those circumstances to where the company itself is used to participate in the behavior or the conduct which is being questioned, if that is indeed the principle,
Your Honor, first of all, I will confess that I have not read it. I read what was said in this text. But it would seem to me with respect that if you confine it to such a narrow class, then you will have a situation, for example, where Mrs. Longsworth would not be able to succeed ever, because it is simply, in this particular case, Mr. Wilson, and the answer would be, well, the company didn't participate, it wasn't the company's thing. That's why you have to attribute the actions and the conduct of someone to the company. If there is required participation by the company, then how does Mrs. Longsworth succeed?
Yeah, what I'm thinking is that when you look at the post-Meridian cases, Supreme Court cases, UK Supreme Court cases, and the Privy Council case from Trinidad of Julian, and the education development.
E-Tech.
Yes, E-Tech, that's right, yes. When you look at these cases, it seems as though the tendency in the jurisprudence is to restrict the attribution in a way that Stone and Roll suggests it should be restricted. I don't know if you want to comment on that.
I would prefer not to, Your Honor, not having read all of those cases. But if the court is inviting further submissions, requires further submissions, I would be happy to do that.
You want to get a submission? Okay.
Yes. In that case, the other side would naturally be afforded the opportunity to also make submissions on that case. Mr. Williams, you with us?
Yes, sir.
Time frame.
Yes. How much time do you need within, well, between now, how much time you need?
Maximum a week.
A week? Okay. And these would be submitted simultaneously. It's not a back and forth thing. So,
2 weeks. By the time they get back to Belize.
yeah, today is Wednesday.
Mr. Corday, I think you may need 2 weeks.
By close of business
The cases are
next week.
difficult, so I'd suggest that 2 weeks may be more practical.
You are more than grateful, recognizing my limitations.
26th. What day is that? A Tuesday. Okay. Let's say by the 26th of November.
Your Honor, unless I can be of any further assistance, those would be my submissions.
Yes. Thank you.
Obliged.
Mr. Williams?
Perhaps, Your Honors, I will be very brief here and to simply say that on the matter of what is a constructive dismissal, a dismissal is a dismissal is a dismissal. And as I understand it, even read within the context of 42, where conduct that makes it difficult or impossible for an employee to remain on the job, which is indeed constructive dismissal. It is a dismissal. So I don't think much is gained from my friend's attempt to say that the notion of constructive dismissal is in fact a distinction with regard to de facto or the jury. It's a dismissal, nonetheless. And therefore, it is our view that that would still keep us within the confines as to, even though the articles speak to dismissal, the articles of the companies speak to dismissal, I respectfully submit that's still within the confines of whether the dismissal is an actual termination, as it were, or some act of constructive dismissal.
So in other words, given what the article said, an employee ought never to construe any conduct to be a dismissal if that conduct is not consistent with the article. Does that encapsulate what you're saying?
No, and what I'm seeking to say is that where there's a conduct that, irrespective of how it arises, an employee can treat that conduct as a constructive dismissal, even though...
Can or cannot?
No,
An employee can.
An employee can,
Yes.
as I understand it, treat a conduct as constructive dismissal. And effectively, I'm saying within the articles, even though the article says only the board of directors in this case can dismiss, where the article says that, it doesn't take away from an employee in the context of the notion of constructive dismissal to...
Do you agree with Mr. Courtney?
No, to the extent, well, I think my point is that whether the dismissal is constructive or otherwise, it's essentially the same thing. In terms of, as to the relationship between the employer and the employee or some officer in the company, in that sense. So I don't think much is gained insofar as trying to distinguish a constructive dismissal from a dismissal which is not a question of whether it is as a result of conduct by somebody in the company or conduct by the company as it relates to the particular employee who either deems it to be a constructive dismissal situation or is actually dismissed by the company. Insofar as the matter of the meeting of July 18th, where the two people in the company had an encounter and they could not arrive at, insofar as what Mr. Wilson, and I preface this by saying that it is our case that this period leading up to then involved a number of proposals. Some were agreed and some weren't, and this last one wasn't agreed. And it is this last one that led to this situation where there was discussion between them and they could not agree. However, one has to look at what transpired commencing in earliest January, February of that year, when Ms. Longsworth went off on maternity leave and Mr. Wilson came in to run the company, so to speak, in her absence, when these proposals were coming out. And on the matter of the third, so it has to be looked at in that context. It's not to be taken in isolation. And without repeating myself, this is why the trial judge who analyzed the issue maintained, in spite of the language that Mr. Wilson used, that this is my view. And despite the notion that if this is carried out, it will go to the root. If it's made effective, it will go to the root of the employee's arrangement as managing director. But the fact that it was determined that it was merely a proposal, in spite of the peremptory language perhaps expressed in the email by Mr. Wilson, the evidence on cross-examination of the parties clearly showed that it was in fact a proposal, but a proposal that was not accepted. And therefore, it diminishes the notion that because of his position in the company, that in fact that proposal should be treated as though it's a fait accompli and is carried. So that when the meeting ended on July 18th, and Ms. Longsworth indicated she would seek advice, in the record we see the cross-examination, and Mr. Wilson, I was shocked because we were still talking, but he was served, the company was served with the claim form the following day. So it looked at it in that way, certainly. Clearly, the intention was not to bring about a dismissal or even a constructive dismissal at all. If one was saying that, look, Mr. Wilson is here, the agent of the company, and if that is his intention, whether or not it is effected, that this is the result. So I would wish to invite this court to look at what transpired in that context, especially because, as I submitted earlier, I suggested that the Court of Appeal had it entirely wrong insofar as the notion that there is a consistent finding of constructive dismissal.
Ms. Wilson, just help me, sorry. Are you saying that the conduct in what you say only reached the threshold of a proposal was not conduct that would make continued employment unreasonable, and therefore does not even meet the standard that Section 42 sets? Is that what you're saying to us now?
I am saying that that conduct, because it was a mere proposal in spite of how it was advanced, in the context of the earlier proposals which were accepted, which were advanced in the same manner, that only in the circumstances where, for instance, there was some action precipitate to, in fact, have the company effect the result, would then be when one arrived at a constructive dismissal, because what the company would then be doing is to adopt the position that this proposal is now, it is resolved, this is made effective. And then that would be the position of the company, which would then be an unbearable or unreasonable, I should say, state of affairs.
So as long as it was a proposal,
As long as it
could not be conduct that made continued employment unreasonable, because it was simply always a proposal. That's what you're saying.
that is our submission.
Okay, good.
I thought you were saying something a little different, though, that as long as it was mere proposals, it couldn't be considered to be attributable to the company.
That's correct. So far as my friend's comment with regard to the rules with regard to attribution, and I must confess I have not read the authorities that have been alluded to, and I'm grateful for the courts pointing to that more recent authority and the time given to consider and make submissions thereon. There are some comments in the Bilta case, which is in the records here, that points in the direction. I had difficulty with Bilta simply that it pointed in all kinds of directions. So I wouldn't want to attempt to say anything that would suggest I've digested Bilta, because really I have not, and I would prefer to reserve until I can look at, quite frankly, Bilta, because it does make that kind of the argument until we have an opportunity to look at the case that has been brought to our attention. I wouldn't have anything further, Your Honors, and if I'm permitted, just to say that it is my first and maiden journey to this apex court, and I am quite grateful for the hospitality and the indulgence that has been given to myself and my team. And I wish to thank Your Honors for hearing us, and we hope that we will have many more opportunities in the future to return to grace, Your Honors. Thank you.
Yes, thank you, Mr. Williams. So we take time to consider, and of course, we look forward to your further submissions, which we would receive on or before November the 26th. Naturally, we can't tell you now when we'll give the judgment, but it would likely be sometime in the new year.
Oblige.